What is a bona fide purchaser? A bona fide purchaser, often abbreviated as BFP, is a person who buys property in good faith for valuable consideration and without notice of any other party's legal claim or defect in title. In simple terms, a bona fide purchaser is someone who buys something honestly, pays for it fairly, and has no knowledge of hidden problems. The law protects such purchasers because they act in good faith and rely on the apparent validity of the transaction. The origins of the concept of bona fide purchaser lie in equity courts in England. Equity developed to correct the harshness of strict common law property rules. Courts of equity sought to protect innocent buyers who had no way of knowing about secret claims or prior rights in the property. By recognizing the status of a bona fide purchaser, the law balanced fairness between earlier claimants and later innocent buyers. The principle eventually spread into both property law and commercial law, where it remains vital today. The key elements of being a bona fide purchaser are good faith. The purchaser must act honestly and without fraudulent intent. Valuable consideration. The purchaser must give something of value, usually money, for the property. A gift recipient is not a bona fide purchaser. Lack of notice. The purchaser must not know, nor reasonably should have known, of any competing claims, liens, or defects in the title at the time of purchase. Consider an example. A person buys a house from someone who appears to be the rightful owner. The buyer pays fair market value, records the deed, and has no idea that a prior unrecorded deed exists giving the house to someone else. If the buyer meets all the requirements of good faith, valuable consideration, and lack of notice, they are a bona fide purchaser, and the law generally protects their ownership against prior hidden claims. The doctrine is particularly important in real estate law, where recording statutes determine how competing claims are resolved. In race notice jurisdictions, for instance, a bona fide purchaser who records their deed first will prevail over earlier unrecorded interests. This system incentivizes transparency and protects those who rely on public records. The principle also appears in personal property and commercial law. For example, under the Uniform Commercial Code, UCC, in the United States, a bona fide purchaser of goods in the ordinary course of business takes ownership free of certain prior claims. Imagine buying a watch from a reputable jewelry store. Even if the watch was previously subject to a dispute between the manufacturer and the store, as a good faith buyer, you are generally protected as a bona fide purchaser. However, there are limits. A person cannot be a bona fide purchaser if they have actual notice, direct knowledge, constructive notice, knowledge they should have discovered through reasonable diligence, such as checking public records, or inquiry notice, facts that would make a reasonable person investigate further. For example, if someone buys land without checking the public deed registry and the registry shows a prior mortgage, they may not qualify as a bona fide purchaser because they should have known about the encumbrance. A curiosity about the doctrine is how it reflects a strong policy choice, protecting innocent purchasers over prior claimants who failed to safeguard their rights. This policy promotes trust in transactions and stability in property markets. Without it, buyers would face constant fear that hidden claims could undermine their ownership, discouraging commerce and investment. In conclusion, a bona fide purchaser is a legal figure central to property and commercial law, embodying the principles of fairness, good faith, and market reliability. By protecting those who buy honestly and without notice of hidden claims, the law ensures stability in ownership and encourages confidence in economic transactions. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.